Court of Greenwood County, Kansas. We are here in 2022 CR 133, the state of Kansas versus Gregory Brian Kelly. Ms. Jill Gillette, Greenwood County Attorney, appears for the state. Mr. Kelly appears in person and pro se. Mr. Kelly, I'd ask again, are you sure you don't want an attorney to help you in this case?
Not at this time, Judge.
All right.
And can I correct the record? It's 2023.
Well, the case is 2022, though.
Okay. All right. That's fine.
It doesn't hurt to check because I do make mistakes on that, but they go by the year the case was filed, and this was filed in 22.
All right. Thank you.
You're welcome. Now then, we are set for motion hearings. Defendant being charged with possession of marijuana, a misdemeanor, paraphernalia, a misdemeanor, operating a motor vehicle without liability insurance, a misdemeanor. Ms. Gillette, did you ever get any indication that there was insurance? Any proof, Mr. Kelly?
Let me look and see if there's one in the file, Judge. It's been a while since we looked at the insurance issue. I don't believe I have any copy of insurance presented to me.
Oh.
That was actually faxed into the office at a previous hearing. We had already determined that it was all good in prior to the incident.
All right. And then we have, I'll double check that as well, Ms. Gillette, to make sure you get credit for that. Sure. Then count 4, operating a motor vehicle without registration or expired tag, all misdemeanors. So let's just check and see if that was formally dismissed. You're alleging that you did have insurance
And registration, yes, I did.
Okay, did you have your car tag?
It was a temporary tag. I was still waiting for the real tag to come in the mail.
Okay, well, if the temporary tag was current at the time, then
It was
that's
not.
okay, and that's the problem with that.
Yes.
Then the defendant on September 14th requested transcripts of apparently the first appearance.
I requested that.
Oh, you did. Okay, state did. And did you get what you were looking for there, Ms. Gillette? Has it been provided?
It's been provided, Your Honor.
Okay.
There was an admission on the record that day, the same as today, that the tag was not current on the vehicle at the time.
Okay. Okay, October 18th of 2022, there does appear on the record to be a dismissal journal entry to count 3 of the insurance. Then November 8th, there was a pro se motion filed, and I think we addressed at least that one. Is that the one that just had a caption but no body to it? Let me pull that up and look at that. Yes, that was one that said motion to dismiss, lack of evidence, but it didn't have anything further. And I believe, Mr. Kelly, you agreed that that one didn't have enough substance to be proceeded on. Am I remembering correctly?
That is correct, Judge.
Then on February 14th, it looks like it was the state's response to the defendant's first motion to revoke, citing that it was too vague, failed to state a claim, lacked argument for which the state could respond. And we all agreed to that at the last hearing. So that's.
He was supposed to file new motions because the ones that were filed that day were all really vague. Basically, they're just statements written out that, or little quotes of law that don't have any argument as to why it applies to this particular case, and nothing new was filed. So I need to respond to. I have done research as to the laws that he has stated or quoted, but other than that, there's not.
Now, moments before that February 14th hearing, the defendant filed, again, it says motion to suppress prior conviction. And some information is given, a statute is cited. So is that the only motion left before us today?
There are two notices to the court
Okay,
that aren't really motions. A notice to the court isn't a motion to ask for relief. Basically, he's stating that he has handwritten some complaint to the sheriff's office and trying to believe that there's some kind of suit. And if you look at Mashaney versus Board of Indigent Defense Services,
excuse me, which motion are you responding to now?
his
Several things that day.
to the court that starts, a complaint has been given to the Greenwood Court Sheriff's Department.
Okay, let me catch up with you, Ms. Gillette. There was the February 14th notice to the court. Is that the one you're referencing to? He's got about.
There's two of them. There's two notices
Okay,
to.
I see that one now. The complaint has been given to the Greenwood County Sheriff Department for deprivation of rights. Okay, and we started to go through these, and because there were so many little points that were raised, I did set it over for today. So is that where you want to pick up, counsel and Mr.?
Yeah,
Okay.
that's fine, Judge. I might have misstated, that was not a complaint filed. It was a claim. And it was given to them for review before I sent it to the bond company.
All right. Well, let's cut to the chase of this. Okay. So are you wanting to deny all of these remaining three charges, the marijuana, paraphernalia, and registration? Are there any of those you want to admit or take a no contest stand to, Mr. Kelly?
Not at this time, Judge.
Okay. And
I only wish to address the due process violations.
Okay. And let me pull those up here. Do you feel like this request for discovery, you've got what you need there?
No, Judge, I have not.
What else are you needing? Did you get copies of the reports?
I still haven't received the full drug analysis report. I'm still missing page 2 of that analysis. And
Okay. Ms. Gillette, do you know anything about page 2 of the KBI lab report?
Judge, we scanned and emailed it to him on November 30th.
it was incomplete.
Is it possible the second page being on the back sheet may not have come through? What is the second page that's missing?
The analytic part of it.
There's only 2 pages. There's this page and there's this page.
You have both of those, sir?
I do, but there's no analytic report on there. It doesn't give a breakdown of any of the substance that was tested. She only said that she tested a substance, but there was no report. There was no basis to her report as to how she came to that conclusion.
Well, I think there is. If you want to point that out to him, Ms. Gillette, or I mean, you're not his lawyer, and he shouldn't need you to practice law and explain that to him. But if you want to just give a very brief.
This is the portion of the lab report that says what the substance is. This is what it verifies, that lab item number 1 is the same as contributor number 1. So this is the number that's assigned by the sheriff's office to the item when it gets certified mailed in. This is the number that the lab gives it when it comes in. So that identifies it as to your case. This information up here identifies it as to your case. This is the officer who submitted it. This says what it was and is a brief description. And then this is when they start the exam, complete the exam, and this says what they found in it and what the net weight total of the drug substance is. So she confirmed that it was THC marijuana and that the weight was 0.54 gram out of marijuana cigarettes. And then down here just says what type of tests she ran to confirm that. And then down here is her certifications of the methodologies. And then down here is her certification of her training of proficiency is correct. At this time, it was over 4,000 samples, but having dealt with these lab technicians, she's probably done over 5,000 by now, or maybe even 6,000 samples.
Okay.
So when they get on the stand, then I qualify them as an expert in the courtroom. And then the lab report can be admitted after they certify their results and their credentials.
Okay, so that
I
should
would
take
do
care of
all
that, Mr. Okay. All right, what else did you feel like you didn't get in your discovery, sir, if anything?
I'm curious, she said something about an admission during arraignment. What was that admission affected to?
What admission did you make during arraignment?
Yes.
You admitted here this morning, and you admitted at your first appear, not at arraignment, at your first appearance, that the tag on the vehicle was not current. And so the transcripts have to be paid for to the court reporter. And if you want a copy of the transcript I've already ordered, you contact the court reporter, Jerry and Noel, and then you can get a copy of that transcript. But you admitted that the tag was not legal on the vehicle, and that is what you were initially pulled over for. So an admission on the record is an admission against own interest, and it's admissible at trial.
Okay, that's why I need to clear up. Appreciate that.
Okay, and I think technically you're both right that the first appearance on a misdemeanor is an arraignment, so that matter's covered. What else? Anything else, Mr.
Yeah,
Kelly?
there is a couple more things. It was mentioned that there wasn't an affidavit in support of probable cause, and I have not received that. You said it was filled.
It was in your discovery.
It
No,
would.
That was
would be.
That was a affidavit in support of complaint.
Well, it suffices for both the complaint and arrest.
Yeah, but it wasn't signed by a judge, so therefore no probable cause determination was ever made.
There doesn't have to be probable cause determination on a misdemeanor. That's for a felony. On the misdemeanor, the probable cause of the officer at the time is sworn to by the officer presented to the judge at the time that we file the complaint.
Yeah,
And it is sworn to under oath, subscribed and sworn to before Gary Murphy, notary. So it is a signed sworn to affidavit.
well, I'm going to object to that because
Okay.
there has to be a certificate of probable cause, whether it's a felony or not. There has to be a determination of probable cause.
And you will find, let me see. Bond, complaint information, arrest. Okay, do you see a warrant on that? Ms. Gillette, inactive warrant? That's
No, inactive warrants aren't necessary under the law.
not necessary. Okay, we had that conversation, I think, last time too, that typically in Butler County, I do sign those after the fact, even though they've already been arrested. In this county, I don't believe they typically are filed, but the court does make that determination upon the affidavit supplied.
And where is that, the proof of that determination?
The fact that you're here today and that this case is proceeding.
Okay, well, for the record, I'd like to object because I believe that the law says that I should have a probable cause determination, and one has not been made at this point to my knowledge.
Okay, but I'm telling you, sir, that I did read the probable cause affidavit, and I have determined that there is enough to proceed at this time.
Okay, I just want to be on
I
the
need Ms.
record.
Gillette to file a document accordingly for me to sign. I can do that, but you were arrested on probable cause. You can be arrested on the officer's probable cause, or you can be arrested on a warrant. And you were not arrested on the warrant, you were arrested on the probable cause. Some jurisdictions, as I say, will do what's called an inactive warrant, but that I do not believe is required. But in any event, I'm telling you that based on the affidavit provided by the officer August 17th, 2022, I do believe that there is cause to proceed with this case, or you wouldn't be sitting here.
Okay, just so long as its record reflects that I objected.
The record will reflect your objection, sir.
Thank you for that, Judge.
You're welcome.
And also, I was wanting to know if there were any more video footage that I have not received, such as a third camera.
What kind of camera? A third?
A third camera. I
Okay,
got the dash cam and the body cam, but I believe there was another camera in the back of the vehicle.
okay.
And I just,
Ms. Gillette?
Not all of our cars are equipped with backwards cameras, and there's not one in this case.
All right.
okay. And then I guess we're down to the other due process violation where the deputy exercised a separation of, he did not separate his powers. He did not take me to a judge, even though I demanded it. And therefore, had he taken me to the judge, I could have cleared up the insurance, the registration, and I didn't have that opportunity. And therefore, my due process was violated. KSA 8-2104, subsection A and subsection 1 says that he had the responsibility after I demanded it to take me to a judge before booking. Therefore, he abused the separation of power, and U.S. Code Section 556, subsection D, says that anytime the courts do not follow due process, they lose jurisdiction.
Ms. Gillette, you have
Also,
oh, never mind. Go ahead.
KSA 22-2901 also states that after arrest, I must be taken immediately before a judge. And I did demand it, and it was not done. So therefore, that's a due process violation. And I don't believe that you guys can continue with due process violations. I have other due process violations.
Let's take that one first. Okay, so
Absolutely.
you're saying that the officer arrested you on the roadside and you said, take me immediately to the judge, and he didn't do it?
Correct.
Therefore, I do not have jurisdiction because he waited until the next available court date for processing.
No, he processed me immediately.
Okay, and you made bond on the same date?
I did. And that was another reason to be brought before the judge. He had no authority to set my bond.
Okay, well, the court sets what is called scheduled bonds. So the court has said, if you have certain convictions, this is what the bond should be. And the schedule for yours was $7,500.
I was also eligible for an OR bond, Judge. By his making that decision, which was not his to make, he put me at undue hardships, and I could have got an OR bond had I went before a judge, and he took that opportunity away from me.
All right, so as I understand your position, anytime an officer in the middle, was this in the middle of the night? It was, wasn't it?
No, it was approximately 6 or 7 p.m. in the evening.
Yep. Okay, after the courthouse was closed. But it's your position that anytime, 24 hours a day, an officer stops someone, they must take them, if the individual asks, immediately to a judge for immediate arraignment?
That's not my decision. That is the Supreme Court's decision, who has said that the courts are open 24/7, 365 days a week.
And okay, and you're entitled to immediate arraignment. And what is your authorities again, please?
Well, KSA 8-2104, subsection A, subsection 1. Also, KSA 22-2901. Both state that he has an obligation, when I demand it, to be
Okay.
taken before a judge.
Quote those, please. Quote the provisions you rely on.
What does that mean?
That means read the statute that you're relying on.
Okay. Yes, it says one person to be taken.
Okay, which statute are you reading from now?
I'm reading from KSA 8-2104.
Okay,
It says when a person is stopped by a law enforcement officer for any violation of any provision of the Uniform Act regulating traffic on highways not amounting to a felony, the person shall be taken into custody and taken without unnecessary delay before a judge of the district court as specified in subsection D of KSA 8-2106 and amendments therefore, if subsection 1 says such person demands an immediate appearance before a judge.
okay,
And then also, if I might be given just a minute
sure.
to look up KSA 22-2901.
Now, is it 2901 or 20? I thought you said 2109.
I've got 2901, Judge.
29, maybe I wrote it down wrong. 2901. Okay,
Subsection 1 or section 1 says, except as provided in subsection 7, when an arrest is made in the county where the crime charged is alleged to have been committed, the person arrested shall be taken without unnecessary delay before a magistrate of the court from which the warrant was issued. If the arrest has been made on probable cause without a warrant, he shall be taken without unnecessary delay before the nearest available magistrate, and a complaint shall be filed forthwith.
now. Anything else you want to say on that?
That pretty much sums that issue up.
All right, and Ms. Gillette, the state have a response to that?
We do, Your Honor. So a suspect may be stopped if an officer reasonably believes they have committed, are committing, or are about to commit a crime, and may demand their name and address, and may take the person into custody if they believe that the crime is being committed, especially if it's a misdemeanor or a felony. And in some circumstances, when individuals are in an exigent circumstance, such as driving a vehicle, they are able to take them into custody and seize the vehicle to stop them from continuing about the way. They may also impound vehicles if they're on a highway, parked unsafely, not tagged, not have proof of insurance in them, because the proof of insurance and registration must be in the vehicle. In this case, the defendant was stopped under the circumstances of having an illegal tag. Upon investigation, he had no insurance available in the vehicle, and that was not given to the state within 10 days. So technically, we didn't have to dismiss that charge, but we did because he did provide that he had insurance at the time, and we were able to verify that. When it comes to bond schedules and the automatic bond schedule program, Kansas Court Rules 23 set out the court-operated bond program and how the rules of the judicial districts should apply. And in 2022's version, The administration rule became effective at February 1st of 1998 and established the procedures and qualifications for release of accused persons from custody in situations other than upon a specific order from a judge of the district court. The automatic bond schedule is set by the chief judge and the judges of the district in accordance with the statute and law set out in the Kansas Court Rules 23. There were certain individuals that wrote letters to the Attorney General back at the time, an Attorney General opinion, AGO 1994-25. So it's the 25th Attorney General opinion of the year 1994, talked about automatic bond schedules at that time as set out by the statutes, and that they require sureties, they require individuals to ensure that the person had to have all these different things, such as their phone number, their address, where they can be contacted, where the surety can be contacted, that a 10% bail bond if cash or surety is allowed. And that Attorney General's opinion upheld the fact that an automated bond schedule can apply because it is prior set for the courts, so that each person would have a bond set by the judge of the district. In this case, Judge Rickey is our current chief judge, but he oversees the other judges in these kind of administrative rules. Each judicial district is allowed to set their own automatic bond schedule in accordance to the rules of the Kansas courts. They have been upheld by the Kansas Supreme Court. Kansas Court Rules 3.309 pretrial release of the Kansas Rules of Judicial Districts in the 2022 version also sets out what offenses are specifically designated for those schedules. Certain offenses have to have C judge, so the person has to be arrested and then the judge makes a determination. It doesn't mean that the person themselves has to be brought before the judge. But due process clauses say that the county attorney, which would be me, files a complaint and or views the ticket that comes from the officer if it's a misdemeanor and someone is arrested. And then I make the determination if the charges should stay as the ticket provides or if they need to be amended up or down. And I do that review within a certain amount of time if someone remains in custody and does not bond out on an automated bond schedule. Then at that time, they have a first appearance where bond may be set and or I submit a warrant to the court with the probable cause affidavit of the officer and a judge reviews it and sets the bond. I know that this is a lot of technical stuff that I am quoting, but that's why a trained attorney often helps someone. And in this case, I believe I'm having to try to teach the defendant the law because he's unaware of it. But the automated bond schedules fall under Supreme Court Rule, Kansas Court Rules 3.309, pretrial release, and Kansas Supreme Court Rule 23, operated bond programs, Kansas rules of the judicial districts. And so there are different rules that allow the judicial districts to set their bond schedules, and it falls under the judicial districts in the actual Kansas court rules. They are ratified and supported by the Kansas Supreme Court, and they continue to be supported by the Kansas Supreme Court. If you turn to Haney versus the state, in that case, the defendant had wanted to sue the Kansas Board of Indigent Defense Services and among others for his arrest and for his defense in his case, believing that he was unlawfully arrested and believing that his attorney did not do the things that were necessary. There is a certain amount of immunity granted under the law when an officer acts under his belief that the person is committing a crime. Then he is allowed to take the person into custody. And the Haney case talks quite a bit about that. and goes into details about the courts, the Board of Independent Services, and everyone involved in the case. So that case sets out quite a bit about immunity for the courts and the indigent defense services, because we have to operate on those bases.
Well, all that stuff about the bond and the set bond and that can all be overridden by the judge at any instant by her saying, I grant you an OR bond. So they're nothing but guidelines. And it has nothing to do with the fact that my due process was violated by not be taken before a judge and allow her or that person, a judge, to decide my fate in that matter. The deputy took that upon himself personally. The Supreme Court case has no bearing on my case because there is no parallel relation to that case in my case. And so bond has nothing to do with the fact that I was denied access to a judge. And I think that KSA 8-2104 is pretty blatant in the fact that it says that I had that right, and that right was denied to me.
Okay, any last words on that, Ms. Gillette?
A judge, due process isn't violated. The Supreme Court's already determined it's not a violation, and that you don't have to be taken in person to the judge for the judge to rule on.
Okay, I'm giving her the final word on
the judge.
I object to her opinion.
Hang on, go ahead, let her finish her thought.
Okay.
The law doesn't mean that you have to be taken personally before the judge. It means that the judge may assign a bond to you in a manner that is fit and determined by the courts and by the Supreme Court and by the law. And in this case, the law has determined that the automatic bond schedule functions as a judge pre-setting a bond. If you don't like the bond, you can contest it at your first appearance. But in this case, the bond was set by the automatic bond schedule, allowing the defendant a swift release, and he was released within the same day according to the bond schedule that is preset by a judge. In this case, Judge Rickey is our chief judge and has been for quite some time, and he would set our automated bond schedule for 2022.
Well,
he could set that for OR, he could set that for surety, he set it for surety. Your last word on this, Mr. Kelly.
Well, I would like to object because, she keeps saying that's the law, but she hadn't stated any laws relevant to that matter. She's sidestepping the fact that I wasn't taken to a judge, and she wants to turn it into a bond issue, but it's not a bond issue. That's only secondary. The issue is the fact that I was denied due process of law by not be taken to a judge after I demanded it. KSA 8-2104 says specifically that if I demand it, it has
Quote that again. Quote that. Quote what it says. Don't just paraphrase it, but quote it. Say it. Read it exactly the way it says.
All right. 2901 says, except as provided in subsection 7, when arrest is made in a county where the crime charge is alleged to have been committed, the person arrested shall be taken, not any paperwork is what she's stating. It says the person arrested shall be taken without unnecessary delay before a magistrate of the court from which the warrant was issued. If the arrest has been made on probable cause without a warrant, he shall be taken without unnecessary delay before the nearest available magistrate, and a complaint shall be filed there forthwith.
Okay, I'm going to stop you there.
Yes.
Now it's my turn to talk.
Absolutely.
All right. You read that statute, sir, multiple times.
Yes.
Never once did you notice or stop or specify a very key provision, and that is, quote, without unnecessary delay, quote. Now, you interpret that as immediate, that you should go and get the magistrate out of bed or out of a church service or whatever he or she is doing, that it has to be immediate. But unnecessary delay could be the next available court date, the next available date the court is open. And that is what you were provided. You were given a bond that a chief judge had set, and he can set those scheduled bonds, OR or surety, and he set it as surety. So you were given immediate bond, which you took advantage of. You were also brought before the magistrate without a unnecessary delay, the next available date for arraignment or first appearance, as Ms. Gillette referred, and you had that hearing, you had that determination. So that I don't find that you have any violations there of rights or laws, and so I'm going to deny that motion, but you are preserved on appeal. So what is your next issue?
Okay, Judge, thanks for that. My next issue is going to be exigent reasons.
Judge, real quick, just so that he's aware, so it's on the record in case of future appeal. If you look at the next paragraph in 22-2901-2, it says, may use, if no warrant for the arrest of the person is before the magistrate, he can make use of telephonic, telegraphic, or radio communication to ascertain the nature of the charged substance of the warrant that has been issued. If no warrant is issued, a complaint, or if no warrant has been issued at that moment, a complaint shall be filed and a warrant issued in the county where the crime is alleged to have been committed. And the nature of the charge, the substance of the warrant, and the amount of the bond shall be communicated to the magistrate before whom the defendant is in custody. So if he remains in custody, then it's not in person. They can use any means necessary, telephone, radio, telegraphic, any kind of form of sending communications to do that. It doesn't say in person.
Right. And that from time to time, as a magistrate, I will get a call about bond. I don't mean to say that that can't happen, but in this case, you were afforded the bond, you made the immediate bond, and then you have a magistrate in-person appearance. So thank you, Ms. Gillette. Now,
Judge, if I may interject, please.
Well, that point is settled. Let's move on to the next one. You were talking about the officer didn't have exigent circumstances to arrest you.
That's correct.
All right.
He pulled me out of the vehicle. I surrendered a knife when I was outside of the vehicle, and he took that knife and he put it back within the vehicle, and then he claimed to use that as his exigent reasoning for officer safety. He planted that knife. That knife was out of the vehicle. He claimed it was a weapon, but yet on the offense report and the arrest report, there was no mention of a weapon, but yet he planted that weapon inside my vehicle after it was already out. I was already in custody, so there was no fear of having anything destroyed, any evidence destroyed. I was not a harm to myself. I was in handcuffs, so therefore I was not a harm to him, and he had no exigent. He created his own exigent reasons. So in other words, he broke the law in order to enforce the law.
Okay, so we are, again, for evidentiary purposes, relying on the officer's affidavit. Is that the document you're referring to?
Yes, he stated himself.
All right.
He posts
He
that.
says on Wednesday, August 10th, 2022, I, Deputy Blake Fisher, working for the Greenwood County Sheriff's Office, was patrolling westbound on US Highway 400 at the approximate 327 mile marker in Greenwood County, Kansas, when I noticed a white Ford F-150 pickup truck also traveling westbound on US 400 at approximately 327 mile marker in Greenwood County, Kansas, bearing an expired Kansas temporary tag of, and then he cites that. So stopping there for a moment. Okay. Oh, and he goes on to say, with the displayed expiration date of 7/22/22. So you're not disputing those facts. You're stipulating that that is correct. He did stop you August 10th because your temporary tag expired 7/22. We're agreeing to that. That's not the issue, right?
No, that's not the issue.
All right. And then he says he noticed the tag was flapping. He ran the temporary tag through his dispatch, and I'm skipping ahead since we have a stipulation to the affidavit. And then to get to the part you're concerned about, I turned on my overhead emergency vehicle lights. Once the vehicle was fully stopped, I approached the driver's side window where I was greeted by the driver, Gregory Kelly, informing Kelly with the reasons of my traffic stop. While I was speaking with Kelly, I smelled the odor of marijuana coming from within the vehicle based off my training and experience. I asked Kelly to provide me with his driver's license, current proof of insurance as well, the registration on the vehicle he was driving. Kelly was able to provide me with his driver's license, however, was not able to provide me proof of the current proof of insurance nor the registration of the vehicle. So you're agreeing to all of that part of it, sir, is that correct?
That is correct so far, yes.
Okay. All right, so then he was standing at your driver's window, ran your license through dispatch, make sure you didn't have any outstanding warrants. Dispatch later informed me Kelly did have a valid license, didn't have any outstanding warrants. After checking the status of, I'm quoting now, after checking the status of Kelly's driver's license, I requested Kelly exit his vehicle, which he did comply with. As Kelly was exiting his vehicle, Kelly informed me he had a knife on his person. I retrieved a pocket knife off of Kelly's front right hand side pants pocket. I secured the pocket knife within the vehicle Kelly was driving. I then instructed Kelly to place his hands on the front push bumper of my patrol vehicle, which he did comply with. Okay, so how does that fit in with what you were arguing, sir?
If you go to the end of that report,
okay,
it explains that due to officer safety and the fact that there was a weapon in the vehicle, that he had authority to search at that point.
Okay, well, the next paragraph says, I then performed a pat-down search of Kelly's person for officer safety purposes. As I understand it, he'd already taken the knife off of you and put it back in the car. I then performed a pat-down search of Kelly's person for officer safety purposes. After the pat-down search of Kelly's person was concluded, I secured Kelly in handcuffs before performing a probable cause search of the vehicle for officer safety purposes due to there being a knife within the vehicle. And that's what you're in reference to?
Yes, it is, Judge.
And I being the only deputy on the traffic stop. Once Kelly was secured with handcuffs, I provided Kelly with his Miranda rights. I asked Kelly if he understood the Miranda rights. I provided him with, Kelly stated he heard what I was saying, however, was not saying he understood anything. I then informed Kelly I smelled the odor of marijuana coming from within the vehicle he was driving. I informed Kelly I had probable cause to search the vehicle based off of the odor of marijuana. Kelly stated he did not give me consent to search the vehicle. I informed Kelly once again I had probable cause to search the vehicle based off the odor of marijuana. Okay, now is there anything else in the report about the knife or anything else you're wanting to argue at this point, or do you want me to continue?
There are no other mentions of the knife after he used that as his.
All right, now, what is it about the knife? Make your argument again about the knife, about what's your argument about the knife? Just make that again, please.
He planted evidence in my vehicle in order to have exigent reasons.
Exigent reasons for your arrest or for the search of
No,
the
for
car?
a warrantless search
Of you or the car?
of the car.
All right, so you think your argument is he was only searching the car because he found a knife in it?
No, he
That
was
he had
only,
put in the car?
no, there was no exigent reason listed other than the knife, a knife that he placed in my vehicle. What exigent reasons did he give? He didn't give anything other than the fact that there was a knife in the vehicle, and that was his reason to search.
Okay, I understand your argument. Your response, Ms. Gillette?
Your Honor, the knife has nothing to do with probable cause and exigent circumstances in this case. I think the defendant is confused because, again, this is a law topic. Exigent circumstances is to prevent the destruction of evidence and or things that are going on. The Supreme Court has determined that the odor of raw and or burnt marijuana coming from a vehicle provides probable cause to be able to search that vehicle. As stated in the deputy's affidavit, he smelt the odor of marijuana, and therefore that gave him probable cause to perform a probable cause search of the vehicle. Exigent circumstances say that when it's in a vehicle that is able to move, as in State v. Goff, Goff, 239 Pacific 3rd, 467, and that was decided in 2010. There is a long history in the state of Kansas going back to the 70s that allow officers to search vehicles based on probable cause of smelling marijuana. He must have the odor, a reason to have initially stopped the vehicle, and a belief that there is that drug in the vehicle. Once the search begins, it's based on the probable cause of the odor. The exigent circumstances that a vehicle is mobile, the vehicle can be easily taken somewhere else and the evidence disposed of, and that the evidence would be mobile at that point because it's in a vehicle. So exigent circumstance does not mean emergency or officer safety. It's a whole different ballgame. Officer safety is a different thing that allows when someone is going to be arrested or removed from a vehicle and be in close proximity to an officer, that for officer safety, they can pat down the person to make sure there's not weapons on them. In this case, there was a weapon present, which is a knife. It was not pulled or brandished, but officers often secure weapons so that they cannot be used to harm. Since Mr. Kelly was removed from the vehicle and he could already be arrested on misdemeanors that are already occurring, he is removed from the vehicle. The pat down is to make sure there's not weapons. He disclosed he had a knife. The knife was secured in the defendant's vehicle. That also prevents the officer from accidentally leaving it in his car, removing it somehow to a different place where it could be lost or messed with. If the vehicle is going to be towed, then it would be secured and included in a tow inventory. And that way it's in a safe place. Deputy Fisher could have also taken the knife back to his own patrol vehicle and secured it there. If someone is being arrested and removed from a vehicle, they can't take a knife into the jail because that's trafficking contraband. They can't take any other weapon or any other things that would be paraphernalia into the jail. And so later on, there would be another pat down and or strip search of a defendant at the jail. But this is a cursory search of a pat just for officer safety to make sure there's no weapons present. And they find all kinds of weapons and all kinds of things on people. And sometimes they feel like something else. And sometimes they brush through and find a bag full of meth and a bag full of marijuana on people. But when you pat them down gently, you're looking for weapons, anything that can hurt you for officer safety. That officer safety check is apart from exigent circumstances on a vehicle. It's not part of the same thing. However, if an officer is patting someone down because a person is mobile and a person can destroy evidence, and they do find a bulge or something in someone's pocket when they're patting them for officer safety, then that becomes evidence that is found and it can be removed and held as evidence. In this case, no evidence was found on the person of Mr. Kelly. It was found in his vehicle with him, which he had sole control over. The exigent circumstances has nothing to do with the officer safety in the knife. That is purely officer safety in this case. And the pat down of Mr. Kelly, he admitted he had a knife. A quick pat down and put the knife back in the vehicle so it's secure and not within reach of Mr. Kelly is not against the law. It has nothing to do with the exigent circumstances. That would be the odor of marijuana and the belief that there are drugs in the vehicle based on the odor of marijuana. They are two separate, totally different things, which is why the knife is never mentioned again. The knife is not something Mr. Kelly is charged with. It would not be evidence. It is not planted. It is simply secured back in his vehicle for officer safety so he cannot reach it.
Okay, Mr. Kelly, I saw you nodding your head negatively, or not nodding, but moving your head negatively as if you weren't agreeing with what she was saying. Or you want to have the final word on this before I make a ruling?
I do, Judge. I think that the prosecutor is confused of the law because she's sitting here talking about probable cause. Probable cause is no excuse to search a vehicle unless you have a warrant. The exigent reason is the only reason that he had cause to search a vehicle, and he didn't list one. So if the knife was not the exigent reason, what was the exigent reason? He didn't list one other than the knife. So we're not here talking about whether he had probable cause. The smell of marijuana might have given him probable cause, but it did not give him authority to search my vehicle without a warrant. Only exigent reasons do, and there's only 3 of them: harm to myself, harm to others, a chance that the evidence might be destroyed. There was no chance of the evidence being destroyed. I was already in custody. So therefore, I could not go back to my vehicle. He had already said that he was towing my vehicle because I had no insurance. So what was his hurry? Why didn't he not just take it back to the yard, file for a warrant, and get probable, and therefore he'd have probable cause to search? He listed no exigent reason other than the knife. So therefore, without exigent reason, which he did not list, he had no warrantless probable cause. There was none. He'd already secured the vehicle. He'd already secured me. There was no reason for him to search that vehicle without a warrant.
All right, thank you, Mr. Kelly. The courts have well settled the fact that the nature of the mobility of the car itself creates exigent circumstances. Leaving the car sitting alongside the road could allow someone to tamper with the evidence, whether it be you or someone else. But the courts have made it clear that the exigence exists in the nature of the car and its mobility, and that does, if the officer has probable cause, he can search the car without a warrant, that he doesn't have to get a warrant, leave the car along the road and go get a warrant. And the officer says his probable cause, let's see.
The second paragraph in page 2, Judge.
Yeah, I'll get there. I was looking for the first paragraph where he said he smelled marijuana, and I thought that was in the first paragraph.
It is.
Yeah, second paragraph, first page. The deputy says, At approximately 18:28 hours, I turned on my overhead emergency lights on my patrol vehicle, initiating a traffic stop on the vehicle. The vehicle came to a complete stop on US Highway 400 at approximately F-75 road in Greenwood County, Kansas. Once the vehicle was fully stopped, I approached the driver's window where I was greeted by the driver, Gregory Kelly, informing Kelly of the reasons for my traffic stop. While I was speaking with Kelly, I smelled the odor of marijuana coming from within the vehicle based on my training and experience. So traffic stop, smell of marijuana coming from within inside the vehicle, mobility of a vehicle. And then when he did the pat down search for officer safety and put the knife inside the car, but then he goes on to explain why he searched the car. And then that's the paragraph Ms. Gillette referred to, and that's second paragraph, page 2. Yes. I then informed Kelly I smelled the odor of marijuana coming from within the vehicle he was driving. I informed Kelly I had probable cause to search the vehicle based off the odor of the marijuana. So he wasn't searching the vehicle based on what is alleged in this affidavit that I understand the parties have stipulated to for this hearing. He wasn't searching because of danger to himself, but rather because he believed a crime was being committed, that crime being the possession of marijuana. And therefore, because the courts have established that he can search the car under those circumstances, he alleges he did so. So in response to your motion, I deny the motion to suppress based on lack of probable cause. I find that he did have probable cause, and the possession or the smell of marijuana combined with the fact that it was in a car on a highway did give him an exigency to search it without a warrant.
Thank you for that, Judge. I would like to record to reflect that I object to that.
And your objection is noted for appeal, sir. Your next next item.
Honestly, Judge, other than all the other violations, which are in fact will be held harmless, those were my complaints that I felt were harmful.
All right. Well, certainly thank you for exercising your rights to challenge anything that you felt. And I understand from what you've just said now that all the motions have been satisfied. Well, that's not the right language. They've been addressed and ruled on. I'm sure they're not satisfactory to you because, as you said, you're reserving your right to appeal. But is there any other issue concerning discovery or suppression that you want to address at this time, Mr. Kelly?
Not in those regards. I do have a question about the complaint.
All right, let's look at the complaint.
Well, it's really not about the complaint. My question is, how does that work when you've got, I've got the possession and then I've got the paraphernalia charge against me. How do they separate the other, such as the registration or any other minor? How does that get separated? Do we go to trial, decide the possession, and then come back to trial again and do the registration?
All right. What would happen? They would all go to trial together, and the state would have the burden at trial of presenting evidence on each and every count that she wants a conviction on. You'd have the right to cross-examine her witnesses, challenge her evidence, present evidence on your own if you wanted to, testify on your own if you wanted to. You couldn't be forced to testify or present evidence. And if you just stayed mute, did nothing, the burden would still be on the state and your silence would not be used against you to determine guilt or innocence. A written set of instructions, written to the jury, this is what you have to find. If you want to find him guilty, you have to find A, B, and C. And if you can't, then you find him not guilty, and it'll go through that on every charge.
Okay.
So the trial would be, again, on all 4 charges, unless a couple of things. Number one would be that if one of the charges were dismissed by the state, and count 3, the insurance was, or if you wanted to admit any of the charges or plead no contest, then they would be taken out as far as the jury trying to find you guilty of them. That's where you sometimes hear about this word plea bargaining, where you and Ms. Gillette might get together and you might say, look, I know I did this, I'll admit to this. If you want to dismiss that, and she might be willing to work with you in that regard, you might be willing to work with her in that regard. And then you might even, some folks even avoid jury trial by doing that.
Right. Well, how would that be done? Would that be done in a court setting or informally at her office, or?
If you want to consult, let's see, Missy, do I still have some time for them to go into a breakout room if they wanted to?
I don't think that that's something I'm prepared to do right now.
Oh, you're not prepared to do it now? Okay.
Required.
All right. Well, usually they don't like to talk to you if you don't have an attorney unless you've waived your right on the record. And you've told me several times that you don't want an attorney and that nobody's making you do that. But I'm thinking I also saw where you filed a document.
Yes,
you
correct.
Prepared that, let me see if I can find that. Ms. Gillette, do you know what date he filed that, which one that was? Was that one of those February 14th notices he filed?
Yes, it was.
Additional violations. We already covered that one. Here it is. Notice to the court filed February 14th. I will be, and I quote, I will be appearing as sui juris, which is of my own right, not underlined pro se, as the court is under the presumption of which is of one's own person, which I am not. I am not waiving any rights, such as the right to an attorney, but rather I am upholding my right to counsel. Now, you're going to have to explain that to me, sir, because if you're upholding your right to counsel, that makes me think you're going to go out and get an attorney. So are you representing yourself or not?
I am representing myself as sui juris, and my right to counsel, as stated in the Constitution, does not mean attorney. It means counsel.
Oh, okay.
There's a difference between counsel and attorney. Counsel could be anything, could be an advocate, could be myself, could be my next door neighbor. I'm afforded the right of counsel, and that does not mean attorney. That has been construed throughout history as meaning attorney, but it does not mean attorney. That is how I'm describing that. So
okay, so you are upholding your right to obtain counsel, non-legal counsel.
That's correct.
Friends, family, yourself, but you do not want an attorney.
That is correct.
You're waiving your right to attorney, but not to friendly counsel from non-legal sources. Okay. Did I get that right?
I'm not waiving my rights to an attorney. I'm only choosing not to have an attorney. I'm not waiving any rights, Judge. I don't mean to be disrespectful, but I'm not waiving my rights to an attorney. You're trying to box me into something there.
No, I'm not trying to box you in, but we are kind of hung up on semantics, I think. All right, so you're not waiving your right to an attorney, but you don't want an attorney, and you're not going to use an attorney. Is that correct?
That is correct, Judge.
And you're going to proceed on your own behalf without having someone appear for you. You're going to make your own arguments, but if you want to go talk to your friend and have your friend give you non-legal counsel, you'll do that.
But yes.
Okay.
Difference.
I think I understand that. And I think we've made a record of that. But the bottom line is you are voluntarily proceeding without a lawyer today and for future hearings, unless you change your mind.
That is correct, Judge.
All right. Well, I'm still going to have the record reflect that you are knowingly and voluntarily proceeding without an attorney, knowing that you have the right to hire an attorney, and knowing that if you cannot afford an attorney, you can apply for a court-appointed attorney, and if you qualify, one can be appointed.
Yes, Judge, I understood that, and
Okay.
that is correct.
All right. So then, Ms. Gillette, with that statement of record, and he wouldn't sign our standard form. As I recall, you would not sign our standard waiver form when you're in the courthouse, right?
Correct.
That's why you came up with this notice to the court of your own. With that, Ms. Gillette, if he wants to call you and negotiate a plea, do you want to entertain that call, or what would you suggest to him at this point on that issue?
If he wants to call and set up an appointment with my office, that's fine. I'm in court the rest of today with you. So I'll be in court all day. I can't do it today.
That wouldn't be done today.
Okay. All right. So that's how that is done in answer to your original question, that if you want to try to negotiate a plea with her, you call her, you set up a time, and then you make your pitch to her, and she can tell you whether she wants to work with you, and you guys can negotiate that. In the meantime, you're still wanting a jury trial if you can't work it out. Is that right?
That is correct, Judge.
And I don't think, are we set for jury trial in June, Missy? Do we have him on our docket?
We do have him set for a jury trial.
Okay.
I believe it is June. Pre-trial June 12th, jury trial starting June 14th.
Okay, so do you have those dates, sir?
Yes, I do.
Okay, now the one when you come in for pretrial,
Yes.
that will be by Zoom on Monday, June 12th.
Okay.
And if you and Miss Gillette before then work out a plea agreement, you can announce it and enter it at that time.
Okay.
If you can't, then we'll plan on the jury trial. But understand, it's like before, there are going to be a number of you set at the same time for jury trial. One will go, the others will have to be moved again. Okay, but if the two of you can work something out, great, we can have you enter at that time.
Thank you, Judge. Appreciate it.
You're welcome. Okay, I don't hear anything else that we need to settle today. Ms. Gillette, does the state have anything we need to resolve or address?
No, Judge, I don't think so.
All right, thank you. Mr. Kelly, anything else we need to address or resolve before we adjourn?
Not in my opinion.
All right, you know well how to call the county attorney. You've got their number?
Yes.
All right, thank you both very much. We will be adjourned of this case, or I should say we'll be in recess on this case.
All right,
Both
thank
take out.
This case highlights a common pattern seen in sovereign citizen-style legal arguments: misinterpretation of constitutional rights and criminal procedure. The defendant's primary mistake was assuming that demanding a judge immediately overrides established arrest and arraignment procedures, and that statutory language like "without unnecessary delay" means instant judicial presentation. In reality, courts interpret this as a reasonable time frame, not an immediate physical transfer to a judge. The judge's reasoning focused on well-established Fourth Amendment doctrine, particularly the automobile exception and probable cause standard. The officer's detection of the odor of marijuana provided lawful grounds to search the vehicle without a warrant. Additionally, the mobility of vehicles creates exigent circumstances, meaning evidence could be moved or destroyed. Legally, the court also clarified that bond schedules and first appearances do not require instant judge contact at the roadside. Administrative systems already satisfy due process requirements. The key takeaway is that internet-based legal theories often conflict with actual statutory interpretation and case law. Courts rely on precedent, not personal interpretation of statutes. This case reinforces that lawful searches and procedural delays are valid when supported by probable cause and established judicial rules.